Hello, everyone. Welcome back to Immigration and Jobs Talk Show. Really good to have you here. Really good to be here myself. I'm Nipasa Pradhan, and yes, we're perfectly ready for another webinar, which is going to go on for about an hour. And before we head on to what the topic is going to be and even welcome our guest, I wanted to read out this very important disclaimer. By watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. Once again, a big hello to everyone and welcome to Immigration and Jobs Talk Show. And we are very happy to have you live with us right now on YouTube, LinkedIn, Facebook, and Twitter also. So today we will be diving into a very critical topic, and the topic is an L-1 visa right for you? We are going to debunk myths and explore alternatives for US employment. And friends, to help us get through this, we are very happy to have our guest for today's webinar, none other than Justin Rivera. Please help me welcome him. He's an immigration attorney who has dedicated his career to business immigration, and indeed, thank you so much for joining us today, Justin. Really good to have you here with us. Justin is from Wasden Immigration Litigation.
Yeah, thank you so much for having me. Looking forward to the discussion.
Absolutely, me too. So, as I already told you, this is our topic for today, friends, and it's going to be very helpful for folks out there. So, the L1 visa is a popular choice for companies looking to transfer employees to the United States, but it also comes with its own set of challenges, misconceptions, and to help us clarify all our doubts, we are going to have Justin guide us through all of this. So, Justin, maybe if you could also tell us what can viewers out there in different platforms where they're joining us from, what can they expect from this session today?
Yeah, I think what we kind of want to discuss today is kind of a general overview of the L1. Obviously, that comes with a lot of distinctions because you're looking at the L1A versus the L1B. There's a lot
Mhm.
of particular nuanced considerations to go into when you look at an L1. Is it a new business, new office being open? Do you have a blanket as the petitioning organization? Is it not a blanket and it's an individual petition? So there's a lot of nuance and there's a lot to get into, especially regarding the evidentiary requirements.
Mhm.
And I'm thankful for the opportunity to discuss that because I do think that it's important to really create that understanding of the distinction between what is required for the L versus what is required for the H, and then the benefits of the L as well. And then even kind of looking at the L as a possible alternative to people that end up not being selected in the H-1B lottery and have to depart the United States, but want to re-enter maybe in the future after getting that 1 year foreign employment. But we'll dive into all of that today and maybe touch on a couple other more specific topics like the L1's relation to the EB1C.
Absolutely, we are. We are. And friends, I'm very happy to tell you at this moment that you can also participate in this webinar. All you have to do is comment wherever you're watching us from. If you have questions, maybe your own cases, maybe you want to get an answer or a tip from Justin here today, you might as well drop your questions in the comments and we'll be very happy to pick them up. All right, so I think without further ado, we should just go dive right into the topic right now. And my first question for you, Justin, is on the screen. What alternative visa options are available for professionals who may not qualify for the H-1B or L-1 visas?
Okay, so I think in order to kind of really delve into that topic, you have to get a little bit of an understanding, at least a baseline of what those visas
Mm,
require, right? So for the
absolutely. So,
H-1B visa, you're looking at a situation where you need to have that requisite degree in a specific specialty in order to qualify. Now, the H-1B is nuanced in that you typically have to go through the lottery in order to be selected, and then have a company file an H-1B for you. Um,
mhm,
versus the L1, you're not looking at that lottery requirement. The L1 has its own specific conditions that need to be satisfied, but it's not as dependent on the randomness of a lottery. So I think that that's
mhm,
a benefit. Obviously, the H-1B has the caveat of the cap exempt employers, which we can touch on a bit later. But anyway, if you're in a situation where um, you're not going to qualify for the H because you didn't get selected in the lottery. You can't find a cap exempt employer, and you don't qualify for the L because you haven't spent that 1 year outside the U.S. with a foreign entity that's connected with the U.S. entity that wants to sponsor the
Hmm.
L. There are other visa options. I mean, I think not to say default, but I think the F1 is something that's leaned upon heavily for people who want to, utilize the work authorization that comes with it. Now,
Hmm.
obviously, for OPT, you're not necessarily in situations where you can immediately use it. You might have to be looking at CPT. Another option, which I think we've touched on in other conversations, is the O1. Now, that O1 is subject to a pretty high evidentiary burden, a pretty high bar to qualify.
Hmm.
So that is something that I think that you would need to look at that if you're somebody who's pretty experienced in your field or has a high level of acclaim or notoriety. Um, you have the country specific visas, the E3, which is oftentimes called the H1B for Australians. But again, that is only going to be for Australians. You could maybe look into the E2 as well. And then the TN visa, which is something that I'm particularly proficient in. But that's again going to be only for Canadians and Mexican foreign nationals. So those are just a couple ideas that you can get into. There's obviously going to be even more. There's a litany of visa
Hmm.
options in the U.S., but each of them is going to carry their own specific requirements, and
Requirements.
no case is going to be as straightforward as you could just say you qualify for this. I think it all would take a heightened level of scrutiny in order to make that determination.
Very well put, and it's so true. So every case is different, and as I mean, it's only when we really consult an expert, an attorney, that we would know which one best suits us. So
Mm.
maybe to guide us through it, if you could help us understand, the key differences between an L1 visa and H1B, and a cap exempt H1B visa, so that people out there have a better idea, just the key differences, and how should one decide which visa is the best for their situation, the best fit.
Yeah, so I mean, the L1, the first part of that L1 visa is that qualifying relationship. And without getting too far into the weeds, it basically means that you have to have been working at a foreign entity for a set amount of time within the 3 years preceding your application for the L. So that's going to disqualify a lot of people, that anyone that's been in the US basically and is looking for a visa option, you're not going to be qualified for that L because you've already been here working. Now, there could be caveats to that. Maybe you did work prior to coming into the US and it's within those 3 preceding years. But generally speaking,
Mhm.
the L is mostly done for people who are outside the US at the time the case is filed for the initial L. The H1B, on the other hand, so you are looking at that nuance of cap subject versus cap exempt. So cap subject is going to be the gross majority of individuals that are going to be on H1Bs. Those individuals have to go through a lottery. That lottery process basically means um, you have an employer that petitions for you, that agrees to register you in a lottery, and then they have your name put into the registration process. A lottery is ran. There's two different types of lotteries. There's your master's cap and your regular cap. Those lotteries are ran and individuals are selected. Their registration notice gives them a period in which to file their H1B. That
Mhm.
H1B, when it's approved, is only active on October 1st. So that would be the first date that you are eligible to begin working on that H1B. Rather, the difference now with a cap exempt employer is a cap exempt employer can actually file an H1B for you at any time of the year. They are not forced to comply with the lottery requirements. Now, cap exempt employers, there are a couple different types. Usually they're
Mhm.
going to be universities, nonprofit organizations, or people that are like institutions that are private but affiliated with nonprofits or placing an entity at a nonprofit. Um, so those are options that can be explored. And then I think something that I often hear about is, okay, well, how do I know if a company is going to qualify as cap exempt? I would just say you need to work with the attorney and the company. The company's probably filed cap exempt H's in the past. what I've seen typically for sponsorships is you're looking at a university, but I've also seen healthcare as an option because a lot of hospitals have a university affiliation. And because of that university affiliation, they can qualify as a cap exempt employer. So that's another opportunity that can be explored. I even think, don't quote me on it, but recently, I believe I saw that the employer filing the most cap exempt H's, or at least LCAs, was actually the Mayo Clinic. So
Okay.
that's, I think, an avenue that can be explored if you're looking for cap exempt employers. It maybe doesn't just have to be a university. But anyway, that's basically kind of the difference between all of those. And I mean, in determining what works best for you, or what's going to be the best option for you, I
Fit,
think it really
yes.
turns on what your degree is, whether you really qualify for that H-1B. There are not always degree requirements tied to the L-1. So I think that whether or not you have a degree matters. And then also where you are, whether you're in the US or outside of the US, I think can play a role as well. And then the relationship, obviously, that you have with the sponsoring employer. So all of those are variables that should be looked at when determining which avenue to pursue for the visa.
Thank you. Thank you so much, Justin, for giving us this brief introduction to these, I mean, these visas, especially L1, H1B, and cap exempt, especially because people are always in a dilemma which visa best fits for them. So, but then again, every case is different. So it's always best to consult an attorney for that. So,
Mhm.
Justin, if you can also provide a detailed overview of the American L1 visa process, including practical insights and common challenges, what should, professionals or entrepreneurs be aware of while applying for this visa?
Yeah. So I think the first thing to really point to is the blanket versus individual L petition. And what do I mean by blanket versus individual? A blanket L is for a company that has what's called an approved blanket. And what this does is it allows them to establish the qualifying relationship between the foreign and US company at the outset of the filing. So what do I mean by that? When you're filing an L, you have to meet certain requirements. First of which is going to be, is there a qualifying relationship between the foreign company and the US entity? Now, when you have that blanket, you've already bypassed that because you already have an approved blanket that shows there's a relationship between company A and company B, either a parent subsidiary, affiliate. There's a multitude of ways, but that relationship has already been satisfied, which it makes it an easier process. The alternative is the individual petition. The individual petition, when you're going to have to do a qualifying relationship, it's going to be a higher burden because you have to show USCIS when you're filing that initial individual petition, which you do have to file through USCIS and then attend a visa interview abroad. When you're
Mhm.
filing initially, you have to show that qualifying relationship, and you do that by showing, certificates of business incorporation. You show that there's maybe an organizational chart showing the relationship between the companies. You show ownership.
Mhm.
There's a lot of evidence that needs to be produced, financial documentation and everything. That makes it a much more difficult process as opposed to if you have a blanket. Um, it's not an impossible burden. It's something you can do. It's just going to take more time. You're also going to have to work a lot more with the foreign entity and the U.S. entity in tandem to produce this documentation. I would also
Mhm.
say because you're filing with USCIS, any evidence that's provided to them that's not in English has to be translated. So you go into a situation where you also have this evidentiary requirement that requires a litany of documentation that also is going to need to be translated when it's submitted. So that's kind of that first part is showing the qualifying relationship between the parties. Then you need to also show that the individual has that requisite 1 year of work abroad in the 3 preceding years. That's typically just done through pay stubs. It's not that difficult to do. I mean, in my experience, it's not been something that I've really run into too many issues with, but that is another thing
Mhm.
that has to be shown. And now, pivotally, you have the distinction between the L1A and the L1B. So L1A is for managers or executives. Those are typically going to be individuals that are managing degree professionals, professionals in either a team or a unit of the organization. Just to give a quick distinction between what's a manager and an executive, the executive's pretty high up typically in the company. They're probably reporting directly to the board or ownership, and then they have everything runs lower to them. The manager could that's not necessarily be super high up on the food chain, but they're typically going to at least have direct reports. Oftentimes, you have individuals who have direct reports who themselves have reports. They show that they manage other managers. So the L1A is like I said, manager or executive, carries with it a maximum period of 7 years. Um, just to touch on it briefly, what that means basically is that you're admitted for typically a period of 3 years, and then you get 2-year extensions. The L1B, as an alternative, is for an individual that has specialized knowledge. Without going really deep into what specialized knowledge is, it's basically an intimate, unique, detailed understanding of either maybe a technology utilized by the organization, a process utilized by the organization, something that really differentiates that individual from other employees, not only within the company, but at large within that field. That they need to use in the United States. It needs to be utilized from the foreign country to the United States. So a couple kind of quick examples of what that could be would maybe be someone who created a technology or created a product, something like that, while working within this company that is now being utilized in the United States. They need this person to come over because they know how to use it, and they need them to train others to use it, or they need them to implement it in the US as well. A lot of times that can be done with IT individuals, people who work in information technology. I've seen people who maybe specialize in medical devices, technologies like that, but it's a broad spectrum, specialized knowledge. I've even seen it applied to HR individuals who they have a very unique understanding of the HR processes of a company that they can't readily find with another person, with another organization. So as a result, they need to bring that individual that's in the foreign affiliate into the United States to perform those functions. And so that L1B is that's a 5-year max. So that's going to be a situation where you're only going to be entitled to that one 2-year extension. Just touching, putting a button on this because I know I'm talking a lot. With the L1, the individual L1, you have to apply it with USCIS and get an approved I-797. So USCIS is going to adjudicate your petition. You do have access to premium processing. And once it is approved, you will schedule your visa interview abroad, attend your visa interview, get your visa, and then come into the United States. And that's kind of an overview of how the process works. It can take a while based on how long it takes to get all the documentation together, especially for those individual petitions. I would say you're not looking at the turnaround that you get with an H-1B because it's a lot more evidence that's going to be required. And as a result, I think if you're realistic, an individual petition should probably take 2 to 3 months to get everything together, to get it filed with USCIS, get it approved. And that's versus an H-1B where I think most H-1Bs, you're probably looking at a turnaround of, maybe 7 to 15, 20 days. So yeah, it's a much longer process.
All right, all right. Thank you so much, Justin, for touching up and giving us a thorough, walkthrough. Thank you so much for clarifying, and I'm sure folks out there really are very much clear about this right now. Thank you so much once again. And I can see Rag. Hi, Rag. Thank you so much for joining us. I think you have joined us earlier as well, so it's really good to have you back. And yes, Rag has a question. Individual L1 has better success rates than blanket L1. Blanket L1 holds better for L1B than L1A. Is that
Hmm.
A question?
This, I mean, it's an interesting idea to posit. I would definitely say that I don't think you can apply a blanket statement. Hilarious, a blanket statement on the blanket L1. I don't think you can really sit back and say the blanket L1 is better for this than it is for that. I'm speaking from personal experience. I represented a company um, quite recently that only did blanket Ls. And they did them for both L1Bs and L1As, and they had 100% success rate. There was no
Mhm.
problem between the two. I think where it matters is the employer. What is the employer's reputation? How much documentation is the employer putting forth? And does the employer have a history of visa denials? So if you're in a situation where you're being sponsored by a company that has a high rate of visa denials at certain consulates, it's possible that the officer is going to look at that application differently than a company that doesn't have those kinds of issues. Um, that being said, the individual L, in my experience, is almost always harder than the blanket L. For one thing, the blanket, you're not
Okay.
having to file through USCIS. You can go apply at the consulate. And so
Okay.
just by the nature of that, you're skipping over the entire step of the application going through USCIS, receiving an RFE, and having to respond to the RFE. I mean,
Mhm.
L1 RFEs are typically rather difficult. They are hard because the evidentiary requirements to be met are going to be pretty high, because they're going to want to see very specific evidence. For the L1A, for example, you're probably looking at information relating to the direct reports, things like the direct reports degrees, maybe examples of their work product, job descriptions, specialized knowledge. They might be asking for specific examples of projects or products that have been worked on by the employee. So it's a lot that's going to be required for that individual L in the event that you get a request for evidence. So I would say I would say you pretty much always want a blanket over an individual just because you're not dealing with USCIS. I mean, I've even had clients that I've represented that have had blankets that their employees could obviously extend their H-1Bs in the US, but the client's like, no, go abroad because it's just easier to apply at the consulate because that way we don't have to go through the burden that USCIS is going to provide. Now that can ebb and flow with administrations, because based on
Mhm.
whoever's in positions of authority, they may provide edicts to USCIS that are targeting certain types of visas more or less. But I think generally speaking, the blankets is probably the better way to go. If you can get it.
Thank you.
That's not easy. There are a lot of requirements to get a blanket. So not every company just has a blanket.
Exactly, exactly. And Rag, thank you for that um, opinion. And there you go. Thank you so much. Also, like Justin, it looks like large multinational companies like Infosys, TCS, Wipro, they have abused blanket L1s, if I'm not wrong. So, and plus L1B workers started working at client sites, and they're required to work from employers' offices. What are your thoughts on this?
So okay, first off, I definitely want to say I'm not going to paint with a broad brush and say that those companies have abused blanket L1s. I haven't worked with those companies, so I'm not in a position to make those statements. If that's information
Mhm.
that's available, then sure we can say it's available. The thing about the L1 is you are supposed to work in the area that is designated within the I-129S, if you're filing that blanket, or the I-129 if you're filing that individual petition. So you are supposed to work. There is that area intended of employment where you're supposed to be working. Now, here's the thing: the L1 is not. There's no LCA for the L1, and what that means is you're not confined to an area of intended employment in the way that you are with an H-1B. So I would push back a little bit and say that with the L1, it's not as rigorous as to the physical work location that the individual is working at. Now, they should work with the employer that's designated on their application, generally speaking. And then they should perform the duties that conform with what was provided in that support letter that was presented when they applied. Those things should all be
Right.
those things should all be the same. Um, What I don't think is okay would be a situation where you're bringing someone in on an L and they basically go to work at a completely different company. So if you're an individual petitioner and you bring someone in to work at company X and then you basically just farm them out to another company and they don't do any sort of reporting. There's no actual work
Paperwork.
relationship between them. Then yes, I think that's an
Mhm.
issue that could be problematic. It's not necessarily the same with the blanket because when you enter with the blanket, there's a little more wiggle room to work with other entities that are covered on the blanket. So it's not as rigorously determined there. I mean, there is nuance. But I'll just put it that way. But that also we're really starting to dive into Canadian entries at the port of entry versus people who have to apply for visas. So I won't go into all of that. But I mean, I would say generally speaking, you're not confined to the LCA requirement the way you are for the H-1B. But I think as a rule of thumb, you should try and make sure that you're complying with what's in the petition. So if you're not complying with what's in the petition, then yeah, I think you're looking at abuse of an L.
Okay. Thank you so much for taking that up also, and Justin for, clarifying and giving us your views about this. And well, thank you for your questions. And I'll just quickly greet our folks out there. So hi again to Rag, and then of course Shaukat, Shivangani, Pooja, Akbar, Dan, Preeti. Thank you so much for joining us. It's really great having you. We will take up your questions. Just stay with us. And I think we should quickly go for a short break. Justin, what do you say?
Yeah, that sounds good.
And
Thanks.
yeah, we'll be back with more questions. And folks out there, don't go anywhere. Stay with us on Immigration and Jobs Talk Show because today we are discussing on is an L1 visa right for you? And we are definitely going to debunk more myths and explore different alternatives and discuss further under this topic. So don't go anywhere. Stay with us.
Consultant seeking a new opportunity? We offer job placement services for US citizens, green cards, EADs, and visa holders. We also sponsor various work visas like H1B, E3, TN, and green cards. 20 plus years of experience in the industry, exceptional employee benefits, highly rated by our employees, global presence with 200 plus recruiters and direct clients. Connect with us. Call us in the number 408 335 6444 or mail us at nipa@higheritpeople.com or visit our website www.higheritpeople.com.
Welcome back after this short break to Immigration and Jobs Talk Show. I am Nipasa Pradhan, your host for today, and welcome back, friends. This is the second half of the webinar we are having, and our guest for today is none other than Justin Rivera from Wasden Immigration Litigation. So it's really good to have you with us, Justin. And I just received a message, rather news about this case in Denton, Texas, and if you don't mind, if we can take a question about that. So, what are the potential
Oh,
immigration consequences? Yeah, for Indian students arrested in Denton, Texas, on charges like solicitation of prostitution and evading arrest, and how might these legal issues affect their visa status and even future immigration prospects? I mean, what lessons can we take away from this case? Because many immigrants out there are watching this right now.
right. So, unfortunately, in that circumstance, that charge, solicitation of prostitution, is pretty generally a crime of moral turpitude. That's usually going to carry consequences that can include inadmissibility, visa revocation, and in some instances, deportation if there's a conviction. Now, that being said, I'm sure that those individuals have hopefully, retained legal representation and are doing everything possible they can to get a plea. If this is the first time these individuals have ever been arrested, then it's likely that they'll, court will work with them to get them lower level defense or some sort of probation. But those charges, when you're looking at the consequences, they really do turn on what is the maximum penalty that can be provided. Is that maximum penalty more than 1 year? Is it more than a set amount of money that could make it a higher tiered problem for them? I would definitely say that even if there is not a conviction against those individuals in the future, they could deal with inadmissibility issues at the consulate abroad. So that could definitely put them in a circumstance where they're going to be potentially asked, at a visa interview about the issue and have to provide an explanation. In that circumstance, they have to be clear on their DS-160s, about what's happened, and then that information really needs to line up. And if it doesn't, then they could look at, getting one of those 221Gs with an inadmissibility finding. So it complicates everything in your legal process, in your immigration process. The other issue where that's going to come up too is going to be adjustment of status. In the future, if they are lucky enough to, be able to apply for that LPR, it's possible that once again, this issue is going to come up. I mean, it's going to come up definitively. So that it's going to unfortunately be something that they're dealing with here for pretty much the remainder of their immigration status in the United States. So yeah, I would say first off, generally speaking, you need to get an attorney, criminal attorney. And that criminal attorney needs to be aware of your immigration status because they have to make special considerations as a result of the fact that you are not a U.S. citizen. I think the next thing that needs to be done is you need to be working in tandem with your immigration attorney so that you guys are aligned kind of on what the strategy is moving forward. Because again, there does need to be that special consideration taken.
So, do you think are they going to be charged with a misdemeanor case or a felony? I mean, felony charges.
It all depends on what the regulation is in the state. It really depends on that. What the regulation is in the state will dictate whether the charge is a misdemeanor versus a felony. And then moving further into that, I'm not a criminal attorney, so it's not something that's well within my wheelhouse. But I would definitely say that I'm hopeful that those individuals don't have any sort of prior criminal history, because if they do, it's exponentially going to make their situation worse. But yeah, I mean, I really think it depends on, do they have prior convictions or charges, and how is that going to play out with the current charge? I think my understanding of the situation is that it was a police operation. So,
Yes, an
maybe,
operation.
yeah, sting operation. So you got to kind of look at the factors that were involved with the particular individuals to see what kind of charges are going to come out. But I'm sure it's something that people will be following because they're going to want to see what the consequences are. I don't know. Did you have anything else you wanted to add on it?
Well, I'm assuming they will be, maybe it's a misdemeanor A with at least 1 year jail term based on the research in Texas. I mean,
Hmm.
state laws. But
Yeah,
since this, I mean, yeah, please say.
yeah, and I think if that's the case, and it carries a penalty of more than 1 year in prison, then that can make the situation even more problematic from an inadmissibility standpoint. And again, that's even whether or not there is a conviction. It still can carry
Mhm.
issues abroad.
Yes. And since you are an immigration attorney, maybe you could give out a tip, or maybe what can we learn from this? Goes without saying, of course, that we should stay away from fraudulent activities or criminal activities, whether minor or major for that matter. But if you could give out some tips for people out there who are watching us, it would be great.
I mean, I have to tell you, in my history practicing, that there are two real things that I've seen mostly come up, and it's issues related to solicitation of prostitution and DUIs. And
Mhm.
those seem to be the two biggest issues that are encountered by non-immigrants in the United States in terms of being charged for crimes. Um, don't do them is the easiest way around it. But also, I just definitely think when you come into the United States, understand that you're here as a privilege and not a right. If you're choosing to come into the United States on a non-immigrant visa, this is not something that is guaranteed to you. It is something that you've been provided as an
Right.
opportunity. You are going to be held to a standard that is likely higher than that of your US citizen counterparts because
Mhm.
you're not a citizen. And you should always strive to operate in your best behavior when you're visiting another person's country. So yeah,
Absolutely.
I do think, unfortunately, that a lot of times these charges befall young people because they're young, and when we're young, we're just not making as
Rebellious.
engaged. Yeah, and we're not making intelligent decisions that are as fully informed as they are when we're adults. Um, so I get that people learn and grow and everything, but at the same time, you have to be cognizant of the fact that there's
Mhm.
such a high bar of consequence to performing illegal activities in the United States while you're here. So just
Right.
be on your best behavior because that's what you're supposed to be doing.
So true. Very well put. And thank you so much, Justin, for taking that up as well. So now
Hmm.
let's get back to our topic, what we are here for. And I think we should quickly take up questions from our audience before I go into my questions again, because they are waiting for a long time. Let's take this one from Mangu. Settled. Infosys settled with the Justice Department for $34 million over allegations of widespread visa fraud between 2010 and 2012. They were the fourth highest recipient of H-1B visas with 6,550 visas. This was in 2013. So, what do you have to say about this case?
I'm not sure. I mean, if that's in relation to the previous comment was about L's. So
Yes,
I was answering
I'm
the
sure.
question as it relates to L's.
Yes.
If that's the case for H-1B visas, I think Infosys, unless I'm wrong, continues to still be one of the higher employers for H-1B visas. So they haven't seemingly been deterred by that by
Yes.
that previous action. Um,
Hmm.
I think just as a kind of general statement, though, on H-1B visa fraud, I think you're if you're the employee in that circumstance, you're really in a bad spot because the petitioner's typically the actor there. They're the ones that are actually committing the fraud because they're the ones that are signing and attesting in the petition, the LCA, that conformance to those activities will exist. I've definitely
Yeah.
seen excuse me, I've definitely seen situations where employees, maybe never get copies of their labor condition applications. So they're not actually told where they're supposed to be working. And then they get put at a work site, but in a consultancy situation where they're violating the
Hmm.
conditions of the H-1B by violating the LCA, but they have no idea. They don't know that. They're just
Hmm.
complying with what the employer has told them to do. And then that puts them in a bad situation because you get into an issue of maintaining non-immigrant status. Um, so unfortunately, it can create a problem. Now, I will definitely say this as a general matter: you should be receiving a copy of your LCA if you're an H-1B employee. You should be receiving a copy of your petition after your case is approved because you need that eventually to go for visa stamping. So those are things that your employer needs to be furbishing to you. And now, is that necessarily them furbishing a physical copy or just providing you online access to the document? That's either way is fine, but you still should have access to that information. And um, I would be vigilant as an employee to make sure that what you're doing is in compliance with what's in that petition. Um, Obviously, you should be working, your employer should be working with an immigration attorney. I wouldn't recommend anyone in the current day and age file any sort of NIV application without representation. um, and if you are, then that's, do so at your own risk. But um, you should be making sure that what you're doing is compliant, because I think that it's very often that USCIS says that your lack of knowledge is not an excuse for the violation that's occurred, or the inability to maintain status or violate status. So yeah, I would just say be sure you know that. And then kind of, just while I'm on my soapbox, I do kind of want to make a point of something, and that is remote work. um, Remote work is obviously fine in today's day and age. People work remotely all the time. something I've noticed recently that's going to come up, and I think it's going to continue to come up as we are kind of always transitioning into an era where we have remote workers, is
Absolutely.
whether or not that remote address is on the labor condition application. As a general rule of thumb, you need to have it on there. If you're in a
Mhm.
situation where you were previously you were previously working exclusively at a client site or working at your offices, and you went remote, and the companies retained their remote policy, it, did you include that remote address on an amendment? Obviously, it may not necessarily be required if you're still in the same metropolitan statistical area. But if you're coming up for an extension, should you make a decision to include it as well? If you're not in the same metropolitan statistical area, did you file an amendment timely? Because
Mhm.
if you didn't, then you're probably looking at a possible violation of non-immigrant status. So those are the kind of like nuanced things to look at, especially I've noticed with not to paint with a broad brush, but I've noticed with consulting companies that sometimes there's not as much attention paid in that situation because the worker is working at a third party site. And that third party site makes a decision to go work from home or hybrid or something like that. The employer
Mhm.
may not have knowledge of that if it's never been provided to them by the employee. So I think you need to be proactive as the employee in that circumstance to make sure that your H-1B is still compliant with its requirements.
So true, so true. And like you were saying about remote working, I think very much the rates are going up. People prefer working from home, but like Justin has mentioned, friends, if you have a change of address, it's always important to update as soon as possible.
Mhm.
Moving on, let's take up another question now from the audience. Arag had another follow up, so let's take that. USCIS preponderance rule holds good for L1 too.
Yes, that's an evidentiary standard. Yes, that's an easy
Okay,
answer. It's for a
thank you.
non-immigrant. So yes.
Thank you, Rag, for staying with us and for your questions. Now
Now,
let's take this next.
whether or not
Sorry.
they actually apply that preponderance of the evidence standard as USCIS, I would argue is debatable. Because for whatever reason, the USCIS definitely seems to operate as if it's a higher threshold for the L. I mean, the L does require more information to be provided, but I do feel personally like you're going to be provided a higher level of scrutiny, unfortunately. But
Okay.
it still should be held to the same to the same standard.
Great. All the best, Rag. I hope that was very helpful. Thank you for your questions. Now let's move on to this next one. Let's take this one from Preeti. I am an Indian national working for a US company in India as a software engineer. My company wants to transfer me to their US office, but I am currently on a 6-month maternity leave. Can I apply for an L1B visa while on leave, or do I need to return to work first?
So the thing about it is it has to be the 3 years preceding your application. So it doesn't have to necessarily be the year leading right up to your application. So what I mean by that is as long as within the prior 3 years you can show that 12 months, then you're eligible to apply.
Mhm.
So I would say that I would argue, yes, you could apply. Now, the easiest way is always to just show the pay stubs for the preceding year before your application, but you don't have to do that. As
Mhm.
long as you can show that um, those pay stubs for that time frame within the past 3 years, you're okay to apply.
Thank you, Preeti, for your question and all the best. I know you'll figure out the best way possible. And congratulations also, I mean, for being a new mom. So, yes,
Yeah,
Preeti,
and I mean
that's really nice.
that's tough though. I mean, if you're on maternity leave and basically it sounds like they want you to come to the US right when you come back to
Right.
work, I'm assuming you're having to move your family with you and everything. I'm sure there's a lot of considerations that have to go in there.
Yes, yes. But I'm sure it's all going to fall in place and everything is going to be good. All
Yeah,
right,
that
Preeti,
actually
thank you once
kind of
again.
gives me into something I haven't touched on at all for this conversation about L1s, and that's the dependent
Yes,
L2.
please
So
tell us about it.
a great benefit of the L, the dependent L, the L2, is that for your spouse, it's going to come with work authorization incident to status. So what that means is literally just by entry into the United States, your partner is immediately granted work authorization in the US, which is awesome. I mean, that's such a huge benefit when you're looking at it
It
versus the
is.
H-1B. With the H-1B, you have your spouse has to go through the issue of getting an approved I-140 before you're going to be able to file for that H-4 EAD. So
Mhm.
I've actually even seen in the past, unfortunately, we had someone get selected in the lottery for a company I represented, a Canadian individual, and they ended up never coming to the US because their spouse made more money than they did, but wouldn't have been
Okay.
authorized to work in the US when they entered. And so because of that hurdle, they never came. And
Oh.
their company went through the entire process of getting that H-1B sponsored for them, getting it filed, getting it approved. But at the end of the day, the employee realized I'm better off where I live for my family because my spouse can't work in the US until I go through the whole process of getting an approved I-140. Um, so yeah, that L2S, that's really awesome. It's really helpful to have that. So just another thing to point to for the L1 and how it's a good
Yeah.
option.
Beneficial. The very beneficial. So thank you so much for highlighting that as well, Justin. Thank you. And folks, I just want to say that you should definitely go follow Walston Immigration Litigation on LinkedIn for more updates on immigration and also the recent Denton County case as well. Thank you so much, Justin. And let's move on now to this next question we have. This is from Sanjay. I am a Canadian citizen and entrepreneur who wants to start a US subsidiary for my existing business. I have a US citizen spouse, but we are currently living in Canada. Can I use the L-1 visa to enter the US and set up my business? And how will my spouse's citizenship impact my immigration options?
So I'll just speak with that from the perspective of the L, because the L you can use it for new businesses, for opening new offices in the United States. Now the thing about that is USCIS seems to be particularly um, picky about new offices, and as such, you are going to be looking at a higher burden than you would if you have an established business. And the thing about that is, you're coming in to open a new office. That means you can't show that you've been continuously doing business in the United States. It just makes it harder. It's harder to show that, there's an actual valid working company that's going to be existing in the US for the individual to work at. It can be done. It is an option. But in doing it, I think you're going to be looking at a more difficult circumstance. That also being said, which we haven't really touched on that much, but the other issue that creates is in relation to the EB1C. Um, the EB1C is an opportunity to apply for an I-140 through the EB1 category. People usually
Mhm.
look at it as a better option to versus EB3 or EB2. However, one of those requirements for the EB1C is that the U.S. company is continuously doing business for a period of at least 1 year. So, why do I bring all that up? If you're coming in to start a new company, you're not able to show that you're continuously doing business for 1 year. So that avenue
Mhm.
is at least initially precluded, where you can't just come in on an L1A and then file an L. You can't come in on L1A immediately and then file an EB1C because you haven't met that requirement. You're going to have to remain for a couple of years. But yeah, you definitely can explore that option. One thing that I think is interesting for Canadians. I know that it's not particularly referenced in this question, but what's something that's unique um, for Canadians is if you have a blanket employer, if you have an employer that has a blanket, an L1 blanket, you can actually
Mhm.
apply for your L at CBP. And that's
Mhm.
incredibly unique in comparison to what everyone else in the world has to do in order to qualify for an L. So, what does that mean? That means you can prepare your L1 packet, bring your necessary fees, and actually apply either at the airport at the pre-flight clearance CBP before your flight, or at a border, at a port of entry. And what's amazing about that is the L1s that I've prepared for Canadians for CBP, they're just not going to have to require the same amount of evidentiary. Like the volume of evidence is usually lesser because CBP is not just going to approve it. You're going to be subjected to questioning, and it's going to be an interview process. But you're not dealing with the consulate officers, and you're not dealing with USCIS. And it's just such an advantage to have for those individuals. So I definitely would say Canadians, if a company is approaching you for an L and the company has a blanket, I would strongly consider that because it really is one of the easiest ways to get into the US on an L1.
It is. What about, I mean, for Indians as well, is it? Is it one
No,
of a good option?
that's what's the Canadians are given this special opportunity that's literally just not available to anyone else.
Anyone else?
If you're an Indian foreign national, you're dealing with going through USCIS unless you're working with a company that has a blanket. So it's just a completely different opportunity. And I think that's definitely why you see companies, I can't give you the names of the companies I've represented, but companies that have a lot of business in Canada and the US, they're using that option because it's a great alternative to the TN visa, because the TN visa has very specific classifications that you need to fall into. And a lot of times, if you're a manager, you're not falling into those classifications. So as a result, they utilize the L1 as an alternative.
Thank you, Justin. Thank you. All right. So, hi, P Man. Um, Thanks for joining us. He's saying hi from Nigeria. I'm from Nigeria, guys. Hi, hello, hola, he says. And now let's go on to Jitendra's question. I am in United States on L2S visa, if I'm right, and currently working. I've been selected in this year H1B lottery. I opted consular processing instead of change of status so that I can continue utilizing L2S. However,
Smart.
when I'll go to India and want to stamp H1B, will that the whole question is not showing here, but let me just read it out. Will
Yeah,
that be
I
a
think
Dropbox or in person? And I heard that if you are in any active visa, then you don't need to go on in personal interview for other visa type. Please
Yeah,
suggest.
look, the easiest answer I can give anyone for Dropbox. I get Dropbox questions all the time. Try to schedule the appointment and see if you're eligible for Dropbox. It's going to tell you.
Okay.
It's the clearest advice I can give on it. If it's an option, it should be an option that's presented to you when you're scheduling. And that's it.
Okay.
That's really all I have for Dropbox. I'm sorry. I get Dropbox specific questions all the time, and that's really just my 2 cents on it. Just schedule, see if it's given to you as an option or not.
Yes. Best way to find out. So thank you so much, Jitendra, for that question. And thank you, Justin, for best advice. Arpita, now let's take this question from Arpita. I've heard that L1 visas are only for large multinational companies with extensive resources and a strong presence in the United States. Is this a myth or reality? Can smaller companies or startups or even sole proprietors use L1 visas to transfer employees to the United States? Or are there specific requirements or restrictions that make it difficult for them to qualify?
Yeah, that's a great question, and I think that I think that's definitely a thing that people think is, if I'm on an L, I got to be with Amazon or Apple or these giant multinational conglomerates that that they do this all the time. They're probably gonna have a blanket. Does it make it
Mhm.
easier? Yes. Is it impossible for a small company to do an L? No, of course not. You can absolutely qualify for an L as a smaller company as long as you meet the requirements. Um, I've done L's for several companies, where they had it come over and worked in the United States and have an office space here that's defined. where you're going to be working, and they are maybe Spain or German or just a company that has that foreign presence that's expanding into the U.S. Those individuals can qualify for an L1. You just have to meet the requirements. Chiefly of Mitch is going to be those qualifying relationships between the foreign affiliate and the U.S. entity. And so I think as long as you're able to show that qualifying relationship and show that the position qualifies and you have that year that you've worked abroad, then you're going to be fine. I will say, touching on individual L's, that something that's important to consider is timeline. I've definitely worked with clients who become frustrated with how long it takes to prepare and submit an L and get it approved. Because with the individual L, it's not done when the case is approved. You still have to schedule and attend a visa interview abroad. So you really need to parse out that timeline. If you're an employer, and you need to be understanding of that timeline if you're an employee. This is not a 2-week thing. This is something that is going to take months. And so I think also that's something that should be baked in to your validity period, the time period that you're requesting on your approval. Because if you're saying, I want a 3-year approval and we're going to start working on my case today, and I want my start date to be September 1st, it's not going to happen. You are not going to start on September 1st, and it's not going to happen. So really, you need to look into that and really understand that calculus when you're looking at the L1. Just getting on my soapbox again.
Well, here's another question. What are the key factors that USCIS considers when evaluating L1 visa applications from smaller companies? And how can I increase my chances of approval if I'm applying from a smaller organization?
Yeah, so I think you want to have a robust petition when you're applying. You're going to want to have to show a lot of evidence. Obviously, that qualifying relationship is very important, because when it's a smaller company, USCIS isn't supposed to provide more scrutiny, but it's, the officer may, as a result of not being familiar with the company, have a little bit more of a, oh, what is this, when they're reviewing it. So I think it's really pivotal to be able to clearly explain the qualifying relationship, show that the company's doing business, show that the company's active and has the ability to pay the U.S. worker. Aside from all of that, which I haven't really been able to get into a ton of, but it's showing the position qualifies. So for that L1A, typically that's going to be managing employees, but it can also be managing a function. USCIS seems to be kind of suspicious of functional managers, because I think it's more so that they don't understand how a functional manager is defined. And so that does require your attorney to kind of put on their teacher cap and really explain, this is the function, this is why it's essential, and this is how it's managed. That needs to be done through two things: your support letter and your evidence. And so I think for that, you're going to be looking at a higher bar when you're that smaller company. What I mean by that is, because a function managed needs to be an essential function. And if you're a smaller company, it's like, oh, I'm just generally speaking, I'm an HR manager. Okay, well, you're an HR manager of a 7-person company. How is that essential? Versus maybe if you're an HR manager of a 45 or 50 person or a 200-person company, maybe that creates a difference. So for that smaller company, you might have that issue. For the L1B, kind of a similar circumstance. You have to show that specialized knowledge. That specialized knowledge should be company specific and unique against when you're comparing yourself to the rest of individuals within your industry, because you're trying to, again, show I have such specific skill sets and abilities that my company has to bring me over. They can't just hire another person in the U.S. job market, because they're not going to be qualified to perform these skills. And so I have to be the person that's being utilized. So I will say, if you're a smaller company, you're going to have to be able to present all of that evidence, and it's going to be tedious, but it's completely doable. It's definitely something that can be done. It's something that I've done working with smaller companies in the past. So I know that it's possible.
Thank you so much. Well, Justin and Arpita as well for your question. Justin, like you were saying about, these visas taking very long. Sometimes it's not just about filing it correctly, but also having that patience and being mentally prepared. So do you have cases where you really have to, console your clients and maybe make them prepared, or tell them not to worry, maybe they'll have another chance next time?
Well, yeah, I mean, so speaking personally, I think one of the biggest frustrations I ever had practicing was an individual L that we did for a company that we filed, and they didn't want to pay for premium processing. So already they didn't want to
Okay.
pay to process. Then they
Hmm.
immediately started complaining about a month after the case was filed that the case wasn't approved because the employee wants to schedule his visa interview. We explained you can't do that
Hmm.
because you don't have the approval notice. You need the approval notice to schedule. So we tell them again, you can upgrade to premium. They don't want to pay it. They're frustrated because they've already paid, which I will say with the L, the fees. There's a lot of fees involved. It's expensive. It is you are paying a lot of money to
Yes.
USCIS, so I will give them that. But they didn't want to pay for premium, and they were upset. So we filed the case, and the case actually gets approved about, I believe it was 3.5 months after the case was filed. It was approved. We get the approval notice. We're very excited about this because it was a difficult case. I can't remember exactly what the position was, but it was an L-1B that took a little bit. I think he was a land
Hmm.
surveyor or something like that. Took a little bit of that extra work. Anyway, we get this guy the approval. We send it to him. We say, hey, we're going to help you schedule your visa appointment. And the employee says, I don't want to go to the US anymore. Like,
Okay.
I just don't want to go. Yeah. He just didn't go. And I'm like, your company paid us X amount of money. They paid USCIS
Yes.
X amount of money. And they've set up everything to move you to the US. And you're just going to change your mind because you're upset that it took too long. And that's what I mean by you really need to make sure that everyone has a clear picture at the outset of what's going to happen. And if the attorney hasn't really explained that, which I promise we did, then the employer needs to make sure that that's clearly explained. Um, because otherwise, you're wasting a lot of time, money, and effort from not only the employer but the
Hmm.
employer abroad. You know, because they have to present all this information too, and the attorneys
Yeah.
that are going through all the time to prepare it. So as a result, yes, unfortunately, people on Ls do sometimes have egos, but as a result, it's just a frustrating key point. So I would definitely say this: your timeline is much longer for an L than it is for an H1. Realize that, know it up front, and plan around it as a result. Because there are factors that come in. Like I gotta say, I gotta give a little bit to the employees. If you have kids and your kids need to
Hmm.
come in by the time the school year starts, you need to factor that in. You need to think
Yes.
about that when you're getting your case ready. If you're saying I need to be there by September because my kids will start school, I need them enrolled. We need to be working on this case, in June, you know, so that we are able to make sure
Three
that we get
months.
everything taken care of. Yeah, you need a couple of months to make sure that it's filed, approved, and you attend your visa interview and everything. So I would just
Hmm.
say, be aware of timelines. It's not the same as an age. It's not as fast as an age. It's just how it is. So outside of that, though, outside of that timeline, I think the L it's an excellent option for people. And the people who I really want to put it out there to is thinking about the L are any individuals who are in a circumstance where you've maxed out your time on your F1, haven't been selected in an H1B, and you've got to leave. Look into the options with your employer. If you have an employer that's multinational, look into the idea with your employer of working at a foreign affiliate for that
Hmm.
1 year, that requisite year. Um, Understand that it doesn't have to just be in your home country. Your employer may have foreign affiliates in different countries. Maybe if you're an Indian foreign national, that means going to Canada, Germany,
Hmm.
Great Britain, England. There are options for you. So you are not necessarily precluded from eventually returning to the US to be employed simply because you haven't been selected in the H-1B lottery. So that's kind of my
Okay.
last little bit to put on this as we're going over an hour, is just that, keep your options open and definitely work with an immigration attorney in the event that you're trying to pursue an L. You would be an absolutely crazy person to try and file on your own.
Thank you, Justin. I'd just say thank you because I think it was very intriguing. This whole session we spoke about and touched about on L1, H1B, the cap exempt, and even the Denton County case. and even got a few examples, I mean, from your personal cases. Thank you so much. It was really fun having this discussion with you today.
Thank you so much for having me. It's always a pleasure.
But I think I still have a lot more questions. Would you want to continue this topic maybe in the coming session, or maybe another fresh topic also? It's cool.
Yeah, absolutely. I'd love to come back on in the future. And then I would also definitely say to anybody whose question we weren't able to get to or weren't able to answer,
Yeah.
there's an email address for you right there, the support@wasden.law. We're more than welcome to, maybe look into scheduling a consultation or something like that for you for your specific immigration issues. And thank you for everyone that took the time to be on here today. It was a pleasure speaking and interacting with you all.
Thank you so much, Justin. And you did half of my work. So there you go. You have the email address, friends. You can also call him on this number, 844-592-7336. And also to get to know more about Wasden Law, go check out their website at wasden.law. Thank you so much, Justin. Once again, you have a great Friday and a happy weekend to you and your family out there.
Thank you. You too. Have a good one.
Thank you. You too, friends. Thank you so much for joining us today. It was really nice having your questions. And um, Rag says, thanks, Justin and Nipasa. Thank you. Arpita says, thanks a lot for such a detailed explanation. So thank you so much, all of you. Jitendra also says thank you. Thank you once again, all you folks. Lovely having you. And if you are looking for project placement or H4TN, green cards, anything related to immigration, if you have any questions, you can also contact me. You can email me as well. You can WhatsApp me in this number, 408-335-6444. That is my number where you can even call me. And you can mail me at nipa@highrightypeople.com. And to get to know more about us, go check us out at www.highrightypeople.com. For now, this is it. Y'all out there have a very fun Friday and a happy weekend ahead. But also, thank you so much for joining in. This is Nipasa saying bye-bye for now from Immigration and Jobs Talk Show.
Consultant seeking a new opportunity? We offer job placement services for US citizens, green cards, EADs, and visa holders. We also sponsor various work visas like H1B, E3, TN, and green cards. 20 plus years of experience in the industry, exceptional employee benefits, highly rated by our employees, global presence with 200 plus recruiters and direct clients. Connect with us. Call us in the number 408-335-6444 or mail us at nipa@highrightypeople.com or visit our website www.highrightypeople.com.